So, good afternoon and welcome to the June People Hour webinar. My name's Paul Menham and I'm a partner here in the gunnercooke employment team, the over 20 strong now gunnercooke employment law team, and today's the 20th of June. Thank you for joining us. So, what are SOSR dismissals? Well, frequently when I talk to employers and discuss SOSR dismissals, there's often talk or a shrug of the shoulders and well, isn't there a better reason, or isn't there a proper reason for dismissal? And what I really want to talk today about is the fact that SOSR dismissals are a perfectly legitimate reason for dismissal. They can affect fair, often very fair dismissals for employees, and they're a useful tool in the armoury. So I'm going to have a talk to you today about what is SOSR and how it can be used. I'm going to talk for a little while about SOSR procedures and what they involve, because there isn't actually a specific SOSR procedure in the same way that there's perhaps an ACAS disciplinary procedure or an ACAS grievance process. So what sort of procedure should you follow in what type of SOSR case? I'll talk through some typical SOSR type dismissals. Now, in fairness, this is it's potentially an unlimited list, and I'll talk a little bit more about that, but ultimately, what I'll look at are 4 of the most common types of SOSR dismissals and when they're used and how to do them, and give you some real life examples of when I've used them in the past. That's the SOSR dismissals in action. As I say, I'll give you some examples of those, some cases that I've worked on, and how to make an SOSR dismissal fair. So again, whilst it can potentially be a fair reason, obviously that in itself does not make a fair dismissal. So how do you make the SOSR dismissal fair? And I'll do that for the next half hour or so. If you do want to ask questions, there should be a button on the GoToWebinar login where you can type questions, and if there's a chance at the end of today and they don't look too difficult, I will happily try to answer some of those questions. If they do look particularly tricky, I'll pretend that nobody's asked one, but please feel free to put questions in the box and send them through. So what is SOSR? Well, SOSR is set out in the Employment Rights Act. It's in section 98. And again, as I say, when I've had discussions, and I've had these discussions with employers, I've also had these discussions with union representatives or solicitors on the other side representing individuals. And they've said, oh, you're relying on SOSR in a sort of a bit of a snobby way, if you like. And I don't really see why that should be the case, because SOSR is clearly set out in section 98. So Section 98(2), as you'll be aware, contains 4 of the 5 fair reasons for dismissing an employee. So Section 98(2) includes conduct, it includes capability, it includes redundancy, and it includes statutory illegality. So the 4 other fair reasons for dismissal are set out in Section 98(2), but Section 98(1) itself, where it talks about the principal reason, includes SOSR here, and it says, in determining whether the dismissal of an employee is fair or unfair, it's for the employer to show the reason for dismissal, and bear in mind in a tribunal, the burden is always on the employer to show the principal reason for dismissal, and that it's either a reason in subsection 2, so that is conduct, capability, redundancy, illegality, or some other substantial reason of such a kind to justify the dismissal of the employee holding the position that the employee held. So that's what SOSR is. It isn't just some of the substantial reason, it's actually some of the substantial reason of a kind to justify dismissal and to justify the dismissal of that particular employee. So, what is SOSR? Well, it's a reason that is, firstly, substantial, albeit we'll come back to that because, again, those of you who are aware of the term substantial in employment law terms know that substantial in employment law doesn't necessarily mean the same as substantial in its normal meaning. Frequently in employment law, substantial means less than minor. It probably means a bit more than that here, but so the reason's got to be substantial. It's got to be a good reason, a good business reason. The reason must justify dismissal. So again, not some lesser sanction. So you need to dismiss the employee. You can't do something else that has less of an impact. And it must justify the dismissal of the job holder, which again is important. And I'll come on to that when I'm talking perhaps about third-party instructions and things. You know, again, does it justify actually dismissing this particular employee? And if you have then SOSR as a fair reason, it's the usual unfair dismissal two-stage test that the tribunals look at. The section, what's normally known as the section 98.2 test and the 98.4 test, becomes the 98.1 test and the 98.4 test. So section 98.1 is SOSR the sole or principal reason for dismissal. And then a neutral burden for the tribunal to adopt: was the decision to dismiss for SOSR reasonable in all the circumstances of the case, in considering the merits, equity, etc., size of the employer, and all of those lovely things that the tribunals look at. More the process generally. So that's an SOSR dismissal. So what should that process look like? Well, SOSR, in order for the dismissal to be fair, like any other dismissal where the employee contests their dismissal as unfair, the tribunal will look at reasonableness and a fair process. So SOSR is not dissimilar to its other cousins, to its other fair reasons. Bear in mind, in a conduct dismissal, the tribunal doesn't decide, well, we wouldn't have sacked this person and therefore the dismissal is unfair. They give the employer a range of reasonable responses. And they say, could it be? Oh, they can only interfere if they could say that no reasonable employer would have dismissed the employee. Ditto for capability, both in terms of performance. So again, it's not the tribunal's decision whether or not they think the employee is not capable of performing the role. They look at the actions of the employer, and were the actions of the employer outside of the band of reasonable responses, in terms of whether the employer believed that the employee was incapable of performing the role, and whether they'd given them sufficient opportunity to improve, etc. Ditto redundancy, pooling, very much a range of reasonable responses. And it's the same for SOSR dismissal. So whilst the employer needs to show that dismissal was necessary, an employment tribunal shouldn't be interfering with that process unless it could be said that no reasonable employer faced with this situation would have dismissed the employee. And a fair process, and what does that process involve? Well, there have actually been various tribunal cases. So far, they've only gone up to EAT level about whether or not the ACAS code of practice applies to SOSR dismissals. The way that the wind is blowing currently, or has blown currently, is that the ACAS code doesn't apply to SOSR dismissals. But, and I'm going to put a heavy caveat on that, or a heavy but on that, even if it doesn't apply, and it probably doesn't, it doesn't absolve an employer from having to follow a fair process. So what would a fair process look like in order to pass the section 98.4 test? Well, in reality, it's probably going to look very much like an ACAS code dismissal. So that's probably going to look like discussing the issue or the problem with the employee, raising the issue and highlighting it to them, consulting with the employee, considering alternatives to dismissal, like you would perhaps in a redundancy situation. So even if the employee can't do the job and, for an SOSR reason, and I'll come on to reasons why that might be the case, what other vacancies have you got? What other jobs have you got that the employee should do? Not that you have to invent a job, not that you have to invent or create work to keep someone busy, but are there vacancies that the employee could do? If you're moving another employee into their role, could that employee switch back? The other things that you would be expected to do, invite them in writing to a potential dismissal meeting, highlighting the fact that that could be the outcome. I would allow accompaniment as well by a union rep or a fellow employee. Give the employee opportunities to speak in the meeting, have their say, confirm your decision in writing, give a right of appeal. So basically all of the things that the ACAS code would say to do, I would recommend that you do in any event. And again, I'll talk through specific SOSR processes when I'm looking at them. But frequently you find with SOSR, it'll overlap or piggyback with other fair reasons or other processes. So, for instance, again, I'll talk in a second about potentially restructuring or business reorganization as an SOSR dismissal. So that's perhaps a typical redundancy situation, but where there aren't actually roles going. There are potentially more roles available, or the same number of roles available. You just need different people to do different things, or the same people to do different things, rather than actually losing any particular people or roles. That might not be a redundancy situation. It could well be an SOSR. It probably is an SOSR situation. But what procedure would you follow? Well, honestly, your redundancy procedure. Follow your redundancy procedure, because that will contain all of the reasonable steps that you're expected to comply with for SOSR. So even if technically it's not a redundancy, it's still probably a fair SOSR process. I'll talk in a moment as well about absence management, because absence dismissals, again, there's an argument that they're not actually on the ground of capability if the employee's fit to work at the time they're dismissed. So they might be an SOSR dismissal. So again, in that situation, well, what would you do? Well, you'd follow your absence management process. It's just you plead in the alternative. So frequently with SOSR dismissals, you will actually piggyback on an existing process rather than actually following a different process. And again, that will make it fair, provided that you do comply with these general issues of fairness, discussion with the employee, consideration of alternatives, invite to final meeting, allowed to be accompanied confirmation in writing, and a right of appeal. So, usual SOSR type dismissals. This is not an exhaustive list. This is definitely not an exhaustive list. But I put down 8 potential SOSR dismissals, 4 of which I'm going to talk about quite a lot and give you some examples on, and 4 of which I'm not. So, business reorganisations. I mentioned that a moment ago, but business reorganisations where potentially it's not technically speaking a redundancy situation are probably SOSR dismissals. Where an employer tries to force through changes to terms and conditions of employment. So obviously terms and conditions of employment can change, and an employer might have good reason for wanting to change terms and conditions. There might be a need to, there might be funding cuts. It might well be that an employee's left and restrictions need to be put in in employees' contracts of employment, and you need to change those. And obviously the best way to achieve that aim, to change an employee's contract, is to do so by agreement. Because if there's agreement, there's not a problem. The contract is varied by consent. But what do you do if the employee doesn't agree or indicates they're not going to agree? Well, in such a case, you might have to end their current contract and offer them new terms and conditions. Now, again, if you do so and they don't accept the new terms and conditions, the reality is they've probably been dismissed for an SOSR reason. Again, fairness we'll talk about in a moment. Protection from competition. Again, I'll talk about that, where you've got an employee and there is a concern that because something's happened, they now pose a risk to confidential information or to clients, etc. And pressure from third parties, really becoming more and more common, particularly with outsourcing of services. The pressure from third parties to dismiss can affect a fair dismissal. Often feels very unfair to the employee, I have to be honest in that situation, but it can be a fair dismissal, and I'll talk through some examples. So those are the 4 that I'll give you some quite strong examples of. The 4, again, from the non-exhaustive list of usual SOSR type dismissals, that I'm not going to talk at length about. Absence dismissals. Realistically, this is where the SOSR type of dismissal I'm talking about here is where an employee has hit too many triggers for absence. So you may well have an absence management process that says if you're absent on more than, let's say, 3 occasions in 6 months, you'll go to a meeting and might get a stage 1 warning. If you're then absent for more than 3 times in the next 3 months, you might get a stage 2 warning. And then if you're absent for a further 3 occasions in the next 3 to 6 months, we may well dismiss you at stage 3 of our process. And that's a relatively typical absence management process. Now, in that type of situation, an employer will probably dismiss the employee, and it'll dismiss them because of the level of their absences and the effect that it's had, etc. And frequently that's pleaded, and that process is absolutely fine. It's not a problem. It's usually fair. A technical lawyer's argument sometimes arises on that in pleadings, in that the employee's representative, in general smarty pants lawyer mode, will say, well, actually, you're saying they were dismissed by reason of capability, and whereas my member or my client was ready, willing and able to work on the day when you sacked him. He'd not had a day off in 3 weeks on the date you'd sacked him. There was no chance of him taking further days off and no prospect of it. So how can you be said to be dismissing him on the grounds of capability? So, smarty pants lawyer's argument, well, there's a smarty pants response, which is fine. When you plead that case, you follow your absence management process, but when you actually come to defend the case, what you say is he was either dismissed on the grounds of capability or on the grounds of some other substantial reason for his failure to achieve regular attendance at work. It's not particularly a different process, it's following your usual process, it's just a difference in pleadings. Reputational risk is an SOSR type of dismissal. So where there's a situation, for instance, where you have a senior employee and either they are accused of either criminal behaviour or just behaviour that is untoward, and that may cause reputational risk to a business. So to give you an example, I don't know, if someone like Philip Green or someone similar, where there has been an attack on his credibility by parliamentary select committees and others, if he had gone to a new business, that new business might not have wanted to now be associated with him because of those issues that have arisen. They might think that it might cause their shareholders, their customers, to have less confidence in the business to be associated with Mr. Green. I'm not saying whether that's right or wrong, but they might do. Likewise, if someone was accused of a serious criminal offence, but outside of work, entirely outside of work hours, not to do with work at all, in those circumstances, the dismissal, what fair reason could it be? Well, it's not illegality, because it's not illegal to carry on employing them. It's not redundancy, clearly, because the role exists. It's not capability, and it probably isn't conduct either, because they've not been found guilty of it. It's not to do with their work. Conduct generally relates to behaviour at work. There are arguments that it can be slightly wider than that. So in a situation of reputational risk like that, where there could be damage to a business, the fair reason would be SOSR. Again, process might be tricky on that, particularly if there are criminal proceedings pending. I'm not going into detail on it, but SOSR would be the avenue and the process that you'd probably follow. Personality clashes. This is always entertaining. Usually occur more either in small businesses or in, sadly, in husband and wife businesses where there is then a breakdown in the marriage or a breakdown in their relationship, or in the instances of very senior employees, so board level employees who just for whatever reason cannot get on. Personality clashes, again, if employees cannot work together, again, and you cannot point to specific behaviour that is misconduct or indeed gross misconduct to actually fairly terminate their employment if you haven't gone through a series of warnings, again, none of the other fair reasons apply, and therefore you would have to rely on SOSR in terms of the breakdown of their relationship. Again, you need to consult alternatives, etc., meetings, but that would be your sensible approach for that type of situation. And finally, breakdown in trust and confidence. Now, I don't particularly like these, but there have been some cases where courts have found there's a breakdown in trust and confidence. It's not gross misconduct, but that the parties have just grown. The employer and the employee just have such a massive distrust for one another. They have grown apart so far. They cannot agree on anything. You can SOSR dismissal in those situations without having evidence of misconduct, gross misconduct, etc. So I'm not going to talk much more about this, or any more about those bottom four. The top four, though, I'm going to have a short talk with you about what you would actually do for each of those and give you a real life example. So business reorganizations. It's common for businesses to restructure. Businesses do this all the time. Law firms do it an awful lot. I actually have one client who aren't a law firm who I think have, through working with them for about 10 or 15 years, have gone into divisions, then switched to work streams, then switched to sector teams, then back to divisions. And it's not uncommon. It really isn't uncommon. Outwardly facing, inwardly facing. It's a relatively frequent thing that occurs within business. And in such situations, you don't actually have a reduction in your number of employees, or you don't have a reduction in employees of a certain grade or at a certain level. You don't need to lose anybody. Nobody is actually redundant. But what you actually need them to do is change their role or change their focus. Now, there are arguments about whether or not technically that's a redundancy situation, and the definition of redundancy might allow for that. I'm not going to go into masses of detail about that. It's a technical argument. It might be, it might not be a redundancy situation. But even if it isn't, i.e. your requirement for managers hasn't diminished, you just want them to do different things, that you still need to change their employment. You might need to effectively dismiss them or give notice on their current contract and give them and offer them a new contract in terms of their new role, if they don't agree to take it. Obviously, if the employee agrees to take the new role, that's fine. It's if they don't and they're not prepared to do it, what's your fair reason for dismissal that you're relying on? And again, you would plead in the alternative. You would say it's either redundancy or it's SOSR. These lovely blue boxes are my examples of different business structures. So the one on the left under the words business reorganizations, where you have one person at the top, a row of 4 below, and 3 of those have 3 people reporting in. You might change that to 4 at the top, for instance, and only 1 of those has direct reports. So there is a change in role, but the requirement for employees generally doing the jobs has not changed. These might or might not be details of partners in departments within a law firm, I don't know. But those boxes indicate that they're not doing anything different. Their role as partner in, for instance, an employment law team in a law firm hasn't changed. The day job hasn't changed. Essentially, though, they're being asked to just restructure and rejig. So the fair reason, if somebody didn't accept that change, is SOSR. What would you do, though, to affect such a business change? Well, you proceed in accordance with your ordinary redundancy process. So you'd deal with it as that type of process. If 20 or more jobs in the current structure aren't in the new structure, there's potentially a collective redundancy under TLURCA 1992, which it gives collective consultation obligation, or sets out collective consultation obligations. So even if you're not actually losing any people, if 20 or more jobs were in the old structure, aren't in the new structure, there's an obligation to collectively consult either representatives of employees or the trade union if they are representing all employees within that, all of whom are affected. If employees don't want a role in the new structure, they're probably redundant, unless they've unreasonably refused to accept suitable alternative employment. Some employers, and again, I'm not going to name any names on this, but I've acted for individuals in this situation, some employers where they have a wonderful, gorgeous, stonking contractual redundancy scheme, and those schemes, I'm afraid, are getting fewer and further between. But in those situations, I have known employers try to call a redundancy exercise a restructure and insist that a new role was a suitable alternative, despite the fact that it was 4 rungs below, etc., and various other things, in order to avoid paying out massively enhanced redundancy terms to employees that were worth sort of 6 figures. If you're doing that, what you do, and the employee doesn't accept, you try to chance it, you call it SOSR. You say it's SOSR rather than redundancy, but generally you'll plead both to avoid it being deemed to be unfair in the alternative in tribunal, but follow a redundancy process. So, the second type that I'm going to go into detail about, a refusal to accept changes to terms and conditions. Now, again, employers sometimes need to change terms and conditions of employees. I'll give you an example in a second, but sometimes it is the case, particularly these days with funding cuts to a lot of public sector employers. Now again, if all of the terms or the majority of the terms are positive, then it is likely that the employees will all agree. And even if terms are negative, sometimes employees will agree. I had a former colleague who had a fantastic situation where something like 100 employees all agreed to take a pay cut to avoid potential redundancies, and it was achieved through union discussion and negotiation. Absolutely fantastic. Every single person agreed to it. Great. They effected a contractual change fully by agreement. That was fab. Sometimes, or frequently, that doesn't happen. So if you seek agreement to new terms and conditions and that doesn't work, it's not possible, it is possible to force through that change by dismissing under the employee's existing contract, and the fair reason for dismissal there again is SOSR, and offering re-engagement on the new terms and conditions. Now again, I'm going to flag, if there are 20 or more employees who you are either dismissing or you are threatening to dismiss in order to effect this change, then it's a collective redundancy situation again under TLURCA. Why? It doesn't sound like a redundancy situation, it doesn't look like a redundancy situation, no it doesn't, but the redundancy definition under TLURCA is significantly wider than the redundancy definition within the Employment Rights Act or elsewhere, and this falls into it. So dismissal of an employee for a reason not connected with their capability or conduct is redundancy for those purposes. And so if 20 or more employees are going to be dismissed, or you're threatening to dismiss, you need to collectively consult trade unions or employee reps for at least 30 days before making the first dismissal, and obviously if there's 100 or more employees, it's 45 days. But again, your obligation here, well, you consult in the employees, their union reps first, if there are 20 or more, but you consult with the employees, you seek their agreement. If it's not possible to agree, then you dismiss on note, you invite them to a meeting, You explain that at the end of that meeting you'll be dismissing them on notice. If they don't accept the new terms, you offer re-engagement on the new terms, you offer a right of appeal, etc. And again, the employee, if they don't accept the new terms and if they therefore are dismissed and they're dismissed for a refusal to accept changes to terms and conditions, then it's an SOSR dismissal, and the fairness of that dismissal is determined by the numbers accepting or rejecting. So again, if the vast majority have accepted, it's very likely to be fair. The business need, again, you can do this. You shouldn't do it for a capricious reason, but provided it's done for a good business reason. It doesn't mean your business has to be bankrupt or on its knees, but there should be a good business reason, not just, well, we think they're overpaid and we want to do them over. Again, whether the union agreed, I appreciate it's quite unlikely, but sometimes it happens. And the effect on the employee, which I always find odd. You're supposed to consider, and part of consultation is considering the effect on the employee, which I always find difficult because what are you going to do? Well, it's going to affect me a lot. I'm going to lose my house. Well, yeah, we still kind of need to do it. I don't understand what you're really supposed to do, to say, okay, well, we'll change everyone else's contract but not yours. But still, it is supposed to be something that, as an employer, you consider. Let me give you a real life example of this one. In a previous life, I worked on a job on this basis for a large public sector employer, and they were facing budget cuts, significant budget cuts. And at the time, they were spending £6 million a year on sick pay, and they had an incredibly generous public sector sick pay scheme, which allowed for most employees to get 6 months full pay, 6 months half pay in the event that they were sick. That amount of money was equivalent to around a further 200 redundancies of frontline staff. So they were having to make redundancies anyway, although they made redundancies anyway, but to avoid a further 200 redundancies, they sought to cut sick pay and make slight changes to the holiday scheme. Again, not massive changes. It was going to affect some employees, and again, they'd go down from something like 35 to 32 days holiday plus bank holidays a year. So don't get me wrong, they weren't on the breadline, they weren't getting minimal rights, and they weren't getting minimal holiday by any means. But that was the proposed change, and agreement was sought, and because it affected a large number of employees, over 10,000, the union were consulted. And in one of the union meetings, astoundingly, the chief negotiator on the part of one of the unions actually said, go ahead, make the redundancies, you're not touching our terms. I actually suggested that they get that blown up in about 80-point font and put that on the union notice board at work, which the employer didn't. In fairness, they were slightly less confrontational perhaps than I was in that respect, but the union didn't agree with it. But in the end, out of 10,000 staff, only 7 refused the new terms and conditions. So in that situation, they managed to effect dismissals on the existing terms, so to contractually change for 9,993 staff, and only 7 instead chose to be dismissed rather than accept slightly reduced holiday and sick pay that was reduced, and it was reduced a decent amount. But only 7 refused those terms and sought to claim that they were unfairly dismissed. So, protection from competition, the third example that I said I talk about in some depth. This is usually where there's a potential conflict of interest situation. It's not where you have evidence of wrongdoing by an employee. If you have evidence that an employee has stolen confidential information and is giving it to another business, you would very much treat that as not only a misconduct issue, but a gross misconduct issue. And these days, you could actually even involve the police, and there are certain criminal offences that might be involved, which tend to frighten the pants off employees who've done it. And you can get injunctions, etc. Not cheap, but by goodness, they tend to work very well. And generally, a sharply worded solicitor's letter gets the information back rather quickly, and the employee is sacked for gross misconduct, usually quite quickly. I'm not talking about that. I'm talking of a situation where there's a potential conflict of interest situation. So usually where an employee has access to confidential information or a client relationship, and they have a close connection to a competitor or an employee of a competitor. So either your employee is a shareholder or has an interest in a competing organisation, or it's where they're generally husband or wife or partner, somebody very close to them works at that competitor in a senior role in a situation where they could do real commercial damage or real commercial risk to you. And what you'd have to show is that continuing to employ that employee in that role would give rise to a real commercial risk. And the test is risk. You don't have to show that you've lost anything. You simply have to show that there is a real commercial risk. Now, again, the process is going to be vital here, and it's one of those situations where you really do have to look at, you go back to that test about whether or not it is necessary to dismiss the particular employee. Could something else happen? So can you consult with the employee, explain the issues to the employee, consult with them and look at alternatives? If it is just client-facing roles, can you put that employee in a non-client-facing role? Might involve a pay cut, might involve something else. I'm never one to say put somebody in a role and carry on paying them a salary that's not justified in that role. I'm definitely not saying that. But what I'm saying is, as an alternative to dismissal, we have these other roles in which you don't have access to confidential information, or you don't have access to clients, and therefore it would be somewhat less of a concern for us for you to have that close connection to a competitor. But you would need to demonstrate clearly that there was no other role that employee could do for you before you could fairly dismiss them on this basis. Now, again, if I give you a real life example, in this case, I acted for a transport service company, or a service company in the transport industry, and the employee in question, her husband and her father-in-law also worked for my client. Unfortunately, the husband and father-in-law were dismissed from that client, funnily enough, for taking confidential information and setting up in competition. So they were dismissed, and they went and they weren't very happy about it. They set up in competition and began to poach and take customers. Now, this was it wasn't a small company, but where they were all located, the particular work location and the particular place where the employee worked was very, very small and close-knit. It was one large room where all employees worked together. So every position there involved access to confidential information, and confidential information that would be valuable to a competing business. Now, in this case, the employee was actually quite canny, and when we raised this with her, she said, well, fine, I'll enter into further restricted covenants, I'll sign a confidentiality agreement. And of course, the difficulty here was, well, actually, it wasn't necessarily that we didn't trust her. It was more that we really, really didn't trust her husband or her father-in-law. And we were concerned that actually just even an innocuous conversation at home in terms of what she'd been doing that day about, oh, crikey, you won't believe, I've had a real issue with a client today, a big client today. And even if she didn't name the client, the chances were that type of information, that type of even innocuous comment could be really useful to the husband, who could then target them the following day, knowing who it was, particularly having worked with us. So, and also the fact that he could, take information, or he could, again, he'd set up in business. So if his business was struggling, wouldn't his wife be more likely to want to assist his business than our business? So it was very, very difficult. It was a horrible situation. It was unpleasant, and she was being particularly canny about this in offering to do extra things. But here, the risk to the employer was huge. In the particular industry, there were very small profit margins, 2.5% to 3% profits, net profits, and the loss of one major client would have had significant consequences. So in the end, they had to dismiss the employee, and they dismissed it on an SOSR basis. So again, the final scenario that I said I'd talk about, pressure from third parties. And again, I think there's probably more ways this can be broken down, but the two typical scenarios where this occurs. The first is where the third party controls either the operation or the place of work entirely and simply refuses to admit or allow the employee onto site or onto those premises for whatever reason. And the second is where the third party customer is basically the only or the biggest customer or client that the employee works on, and the third party says, I no longer want that employee on my account for whatever reason. Now, again, there comes more of an issue where it's a discriminatory reason. I'm not going to delve into that here, but issues might arise in respect of that. But where there's pressure from third parties, either way, what a tribunal or court will expect you to do is to test their resolve within reason, i.e. push back and not just take it the first time they say, I don't want Bob working on my account anymore. Say, oh, okay, yeah, sod Bob, we'll sack him. But to actually say, is there nothing we can do? Will you not give Bob a further opportunity if we do X, Y, and Z? You're supposed to, within reason, do that. Now, I do appreciate that in a lot of client relationships, that might not be a good idea. I do sometimes think tribunals expect you to suspend disbelief, because let's be fair, if a lot of your clients say this, if they say jump, you'll say how high. But it is anticipated that you will at least within reason test their resolve. I would also strongly advocate obtaining evidence of the instruction itself. Now again, it's not absolutely vital. You do not have to have, it's not a rule that a court will say it must be a written instruction from a client. But the difficulty arises in terms of, well, how clear was that instruction? And the burden is on you to demonstrate that that was the instruction and you had no choice. So it is better evidence by far to have a written document detailing that the client has insisted that Bob be taken off the account. Now, frequently, if you ask a client to do that, they will frequently say, no, it's your problem. We're not getting involved in litigation. Hey, if we wanted this hassle, we'd employ Bob ourselves. We don't. You do it, you sort it. And there is a sort of cannier way of dealing with that. And my sort of cannier way of dealing with that is actually you writing to them. So actually emailing and saying, dear Fred, following our meeting, you were clear that you no longer wanted Bob on your account because you had X, Y, and Z issues with him. I did seek to try to persuade you to allow us to continue with Bob, but you were adamant that you wanted him removed. Therefore, in accordance with your instruction, with effect from today, Bob will no longer be your account manager. Instead, it'll be Jane, and Jane's coming out to a first meeting with you on next Monday. If you've got any queries or I can help any further, please let me know. And basically, that's your evidence, that's your written evidence there in you writing it to them. And essentially, Fred, or whoever it was I was sending it to, would have to then come back and say, I didn't say that at all, which I think you're unlikely to do. They might not like the fact you've put it in writing or detailed it in writing, but again, if you put it in such a way that it sounds as though, look, client care, we're doing what you asked, absolutely fine, hope everything's good, just confirming what we've discussed. You've got your evidence of the clear instruction, you've got your evidence that you've tried to test their resolve within reason. That's really useful evidence to you. Again, you've got to consider alternatives. So again, it's got to justify dismissal. So just because you're removing somebody from a particular client account doesn't mean that they can't work somewhere else for your organisation. I frequently think in these situations, if in my scenario, I can't remember who it was, I think Bob was taken off the account and Jane was put on. Well, surely Jane had lots of work that Bob could now do. Because if Jane is going onto this account, there's space for Bob to do her work. So why can't you just swap them? Now, there might be a good reason, but it might be that Bob's not capable of doing that work, in which case, absolutely fine. If he's capable of doing it with a month's worth of training, you'd be expected to train him for a month. And also, as I say, it's to justify dismissal. So again, if the client has raised legitimate performance concerns about Bob, there's no concern, there's no issue with one, removing him from the account, but two, giving him a performance warning and advising that his performance needs to improve, or giving him a stage 1 or stage 2 performance warning, whatever it's going to be. So that again, even if you do put him on another account and he doesn't perform there, you could potentially look to fairly dismiss perhaps at that stage, which might be a way to proceed even if you don't have to dismiss now. But you consider alternatives. You can consider the injustice to the employee, which again is a bit, I always think is a bit of an odd one, because again, there's frequently injustice to the employee, but what on earth can you do about it? But I don't quite know. The courts expect you to do it, so I would suggest that in your dismissal letter or in your minutes, you say that you have considered it, but that there's nothing you can do. And you're expected to consult with the employee as well. You're expected to talk to them about it. And again, that can be a difficult situation, because they'll say, well, can you go back and ask? And a lot of the time you probably can't. But you need to consult with them, explain it, look at alternatives again, invite to meeting, dismissal letter, right of appeal, right of accompaniment, etc., as you normally would. I'll give you 2 examples. Pressure from third parties. First example, employee works in a third party's secure premises. That may or may not be a prison. The premises are entirely under the control of that third party, perhaps a prison governor, and the employee does something that annoys the third party. I'm not going to go into full details about exactly what the employee did. If you wanted to look on my LinkedIn profile and then you looked in at Google, you would probably work it out, I'm sure, but I'm not going to say it on this podcast. But somebody did something that might have annoyed a prison governor a lot. And the prison governor refuses security clearance to allow an employee to enter the prison. Now, this employee didn't work for the prison, they worked for an education establishment providing education to inmates within the prison. But unless they have security clearance, and they're simply not admitted to a prison. Funnily enough, prisons are quite choosy about who they let in and who they don't. And if the governor says that you're not coming in, funnily enough, you're not coming in. So you can't do your job. Now, in this case, the employer attempted to persuade the prison governor to change her mind. Goodness, they tried to get her to change her mind, but she was not for changing, which is fine. The employer, in this case, also unsuccessfully looked at other sites. They looked at other prisons and education establishments, but the employee was being a pain in the bum and refused to work anywhere except this one particular prison. So in that situation, the employer couldn't do anything but dismiss, and they did. Absolutely fine, fair dismissal. A different type of pressure from third parties, the second example that I gave, where the employee works 90% of their time on a specific customer's account. And again, that customer says, well, actually, no, I don't want Bob on this account anymore. Again, you're supposed to look at alternative work. As I highlighted before, it has to be done by someone else, which creates a vacancy. Can you switch the two employees over? In this case, it was quite useful. I mean, in this case, the employer didn't want to have the employee still working because they said, well, they've already wrecked one client relationship. I don't want them to wreck another. And I said, well, it's not quite that straightforward, actually. The employee, funnily enough, made it more straightforward because the employee refused to do any alternate work. They refused to do any other duties, which again made it very, very straightforward. So we said, fine, you give us no choice. We have to dismiss you. So again, affected a fair dismissal. So actually, I'm going to deal with this question, I think, before I go on to the summary, because somebody has left a question which is very helpful. Thank you. I've heard it suggested that a clash of personality should be treated as a conduct, arguing a breach of values or code of conduct. Any thoughts? It can be. It's going to depend. If there is a clash of personalities and there is clear evidence of misconduct within that clash of personalities, then yes, definitely you'd treat it as misconduct and you'd give misconduct warnings. You'd go through your stages of warnings, so verbal, written, final written, or whatever your stages are in accordance with the ACAS code, and you'd go through those. And it's always easier if you can do staged warnings and you're prepared to do that. It's often much easier to do that. It looks fairer, and tribunals, in my experience, tend to have a lot less sympathy for an employee who's received verbal, written, final written warnings and is then dismissed and doesn't improve their conduct. So in those situations, if you can actually point to specific misconduct and breach of values or whatever it is by employees, then great, do that. That's fantastic. The situation I'm talking about is where you have a clash of personality and there aren't issues of misconduct, or it's got so bad that you just have to do something now because you can't keep these two together. They are simply not working. It's damaging the business. You've not got time. You've not got opportunity. There's nothing you can actually pin down to actually say, oh, well, it's misconduct to not get on with your employee. Unless you can pick out certain things, it takes time to go through that type of process. And unless one of them's daft enough to do something that's gross misconduct, you're probably not fairly dismissing them. So it's that sort of type of situation that I'm talking about. But no, it's a super question. And yeah, if you can, do go down a conduct process in a situation where you can demonstrate they have breached conduct rules. So great, thank you ever so much for that question. So, in summary, look, SOSR is a legitimate business tool. It's, I've jokingly referred to it in the past as the dustbin of fair reasons, and it is to some extent because it's or the A-team of fair reasons. You know, if you've got a problem and no other fair reason can help, you use SOSR sort of thing. It is a legitimate tool, though, and provided you have a good, substantial according to the legislation, but a good business reason that does justify dismissal, it's a legitimate process. It needs to be a reasonable decision within a band of reasonable responses, but expect a tribunal to be sceptical about why you couldn't continue to employ in a different role or doing something different and show that you have exhausted that. And you'll be expected to follow a reasonable process that probably looks a bit like an ACAS code or your existing procedure that you piggyback on, if applicable. Always consider alternatives. Consultation in this tends to be key. It's the type of thing where I wouldn't just have one consultation meeting. There are many things where I just have one consultation meeting, but do try to exhaust consultation. Do try to show that you've sat down and discussed everything you reasonably can with the employee. It's just there isn't a solution other than dismissal. And finally, I've said do what's right for business. And what I mean by that, again, is look, gunnercooke, we tend not to be the lawyers who quote you the law and say, no, can't do that, can't do that. What we try to do is work with you to actually find something that works for your business. So in a lot of these situations I've highlighted, and in other situations, frequently, look, would it be a fair dismissal? It might not be. Or it might not be the fairest dismissal. It might not be platinum plated. But in a situation where you're thinking, we need to move this employee on, this isn't working, we need to do it. Well, SOSR sometimes, as other fair reasons do, gives you a chance to move down a process and start a process. Even if you then move on to a discussion about a settlement agreement, or even if you dismiss first and then move on to a discussion about settlement, it at least gives you that lever or that hook to have that discussion and to move the employee on and to then talk about settlement. And at a time when unfair dismissal, firstly, employees need 2 years to claim ordinary unfair dismissal, and secondly, unfair dismissal compensation is capped at 12 months. It is the opportune time to do what's right for your business and not keep an employee simply because you can't lever what they're doing into one or the other for fair dismissals. But look, thank you ever so much for listening today. I haven't got any other questions that have come through, so thank you very much. We will forward you details of the next People Hour session, which will take place in July. If you do send any further questions, I'll follow up to them on email, and you should be sent you can log on to our website to obtain a download of this recording within the next couple of days. I've been Paul Menham, and thank you ever so much for listening. Enjoy the rest of your day.